out of a commercial space in Sydney triggers a strict legal and financial process under your lease agreement, far beyond a simple packing and moving day. This extraction machine is pulling years of embedded soil out of the carpet fibers, a level of structural restoration landlords require to meet baseline standards. NSW Commercial Property Law and the Commercial Arbitration Act 2010 define this as make good cleaning, your legal obligation to return the premises to their original condition. Friction arises because outgoing tenants often view cleaning as an aesthetic task, while landlords view it as a mandatory restoration to the property's commencement state. These subjective standards lead to frequent conflict, particularly in Sydney CBD office towers, where property managers enforce zero-tolerance policies for surface marks or odors. In many cases, a space that appears clean to a tenant fails to comply with the landlord's official dilapidation report, the technical assessment used to quantify required work. Failing to meet these standards results in withheld security deposits, aggressive disputes at the NSW Civil and Administrative Tribunal, and significant financial penalties. Approaching end-of-lease cleaning as a legal compliance measure is the only way to protect your company's cash flow during a transition. Section 17 of the Retail Leases Act 1994 governs most commercial property leases in New South Wales, providing a specific framework for tenant liabilities. This law explicitly prevents landlords from forcing tenants to pay for fair wear and tear that occurs through normal use of the premises. As a tenant, your liability is limited to rectifying genuine damage and restoring the basic hygiene of the space to its original baseline. This matrix draws the line. Minor scuffs and slight carpet fading are landlord responsibilities, while deep scratches and burn marks are yours. Landlords frequently attempt to reclassify standard wear as tenant damage to fund property renovations, particularly concerning carpet stains versus full replacement. Disputing these claims requires the tenant to provide clear evidence of the property's baseline condition at the start of the lease. The definition of normal also changes with time. A 3-year lease term naturally incurs higher levels of acceptable wear than a 3-month occupancy. Knowing these legal distinctions is your primary tool for blocking a landlord from charging premium restoration fees for standard legal wear. Small businesses in spaces under 100 square meters often consider using their own staff for the final clean to preserve capital. However, in-house cleans usually fail inspections because staff lack the training to address HVAC grills, high-access dusting, or specialized grout restoration. This data shows the risk. In-house cleaning recovers the full bond only 60% of the time, whereas professional make-good services see a 95% success rate. Professional cleaning for a small office ranges from $500 to $1,200, while mid-sized spaces cost $3,500 or more. These professional crews utilize heavy equipment, like industrial floor buffers and hot water extractors, that internal teams simply don't have access to. They also ensure the property meets technical commercial standards, such as the AS/NZS 3733 requirements for carpet restoration. Achieving this level of deep sanitization and restoration typically requires a dedicated timeline of 2 to 7 days. The cost of a professional crew acts as an insurance premium that protects your much larger security deposit from forfeiture. Performing the clean is only the first step. Securing your bond depends entirely on your ability to prove the work was completed to standard. Defense begins with time-stamped photographic evidence. Next, you need compliance checklists documenting applied standards. This objective evidence provides leverage against a subjective dilapidation report, ultimately compelling an immediate bond return or ensuring a successful tribunal defense. The NSW Civil and Administrative Tribunal, or NCAT, evaluates these disputes based on hard evidence, not verbal accounts of the property's condition. Armed with a professional paper trail, you can also utilize the Commercial Arbitration Act 2010 as a faster, lower-cost alternative to a court hearing. Professional documentation creates a factual defense that neutralizes the landlord's subjective opinion and protects your capital. Your strategy for a smooth exit should be tailored to your specific business type and the current stage of your occupancy. For those who haven't signed a lease yet, use your leverage to explicitly define normal wear and tear within the contract itself. Demand a clause requiring an independent dilapidation report before you move in, ensuring you aren't held liable for pre-existing issues. If you are an SME operating in a small office space, your priority is risk mitigation. Avoid risking a multi-thousand-dollar bond to save a few $100s on internal cleaning labor. The math rarely favors the tenant in that scenario. Large or complex enterprises, such as medical clinics, labs, or food service facilities, face much higher scrutiny. Generic cleaning is insufficient for these spaces. You must ensure your contractors provide HACCP CP or TGA-compliant checklists to meet your specific lease obligations. The power dynamic favors the landlord at the end of a lease, but preemptive planning can rebalance that relationship. The cost of hiring professional specialists is always lower than the cost of legal disputes and lost security deposits. Precise planning, professional execution, and meticulous documentation are the only reliable ways to close a lease while keeping your capital secure.